All right. I will now call the Senate Committee on Judiciary to order for Thursday, March 25th, 2021. Will the Secretary please take the roll?
Vice Chair Cannizzaro.
Please mark Vice Chair Cannizzaro present as she arrives, and I'll try to make a note of it as well.
Senator Orenshaw.
Present.
Senator Harris.
Present.
Senator Settlemeyer.
Here.
Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
And I am here. Thank you. We are also joined by our staff, Patrick Guinan from LCB, and our committee counsel, Nick Anthony, remains available to us should we have any questions for him, although he cannot be here because he is busy drafting legislation. I am going to start today's meeting with the BDR introductions. Pursuant to Senate Standing Rule 14, committee members must vote to approve the drafting of legislative measures requested by the Senate Committee on Judiciary on behalf of various entities. Please remember, a vote in favor does not indicate your support for the bill, but merely allows the bill to be drafted. Today, I request the committee's approval of two BDRs. Both are from the Interim Committee on Child Welfare and Juvenile Justice. BDR 5-498 revises provisions related to juvenile justice, and BDR S-500 requires the implementation of a pilot program relating to the housing of certain youthful offenders. Are there any questions on these BDRs? Do I have a motion?
Move introduction, Chair.
All right, we have a motion from Senator Orenshaw to introduce BDR 5-498 and S-500. Is there a second? I see a second from Chair Harris. Senator Harris, any discussion on the motion? Not seeing any discussion, will the Secretary please take a roll call vote?
Senator Orenshaw.
Yes.
Senator Harris.
Yes.
Senator Settlemeyer.
Yes.
Senator Hansen.
Yes.
Senator Pickard.
Yes.
Chair Scheibel.
Yes, thank you. And with that, the motion passes to draft BDR 5-498 and S-500. Also, before we get to our two bill hearings for the day, I would like the record to reflect that Vice Chair Cannizzaro is here, and we will open up the work session on SB 107. Mr. Guinan, would you please lead us through the work session document?
Excuse me, yes, thanks, Chair Scheibel. For the record, Patrick Guinan, Committee Policy Analyst. As the Chair mentioned, we have one bill on work session today, that is SB 107, which was sponsored by Senator Orenshaw, and which this committee heard on the 18th of February. Senate Bill 107 establishes a 4-year statute of limitations to commence an action for wrongful termination of employment. Also requires that the existing default 4-year statute of limitations must apply to causes of action where they are not otherwise expressly prescribed by law, regardless of whether the cause of action is analogous to any other cause of action for which a statute of limitations is expressly prescribed by law. And after the initial hearing on the bill, Senator Orenshaw conferred with some folks and has presented an amendment, which is here for you today, both summarized on this page and attached on the following page. It makes two changes. First is to delete item E in section 1 sub 2 of the bill concerning the 4-year statute of limitations. The next item 2 is to add a subsection or an item G to subsection 1.4 of the bill, which concerns tolling of the 2-year statute of limitations. And Chair Scheibel, I believe that we have Mr. Kemp from the NJA here today to discuss the amendment and explain it in detail to the committee members, if that's your preference.
Thanks. You know, it was my understanding that we would have Mr. Kemp, but I do not see him here.
Chair, he may be on the phone. I know that the amendment reflects a lot of talking and negotiations between stakeholders. And while I cannot say that I think every stakeholder is supportive, I believe that the majority of folks who've reached out to me and to Mr. Kemp and Ms. Cardavani are supportive of this amendment. He might be on the phone. Otherwise,
All
I'm
right.
to.
Mr. Kyle, is it possible to track down an individual on the phone in order to have them contribute to this hearing?
Yes, Chair Scheibel, that is possible. If I could just have the name once again, I will ask to see if he is in the list.
All right, we are looking for Mr. J.P. Kemp.
Madam
Thank you
Chair.
very much.
He is on the phone, I believe. I'm happy to answer any questions as well. I'm not an employment attorney, but I certainly give my best shot at it.
I would rather hear from Mr. Kemp if we can find him.
Yes, thank you, Chair. Mr. J.P. Kemp, if you are on the line here in the Zoom, will you please press *9 now to raise your hand? And Chair Scheibel, I do have him here. Just let me know when you'd like me to ask to unmute.
Yes, please go ahead and have Mr. Kemp explain the amendment to us.
All right. Mr. Kemp, please press *6 to unmute yourself. Once again, Mr. Kemp, if you can hear me, please press *6 on your phone to unmute your microphone. All right, you are
Yes,
unmuted
hi.
Yes, sir, you're unmuted to the meeting. Please proceed, Chair.
Am I recognized by the chair? I'm sorry, I didn't hear.
Madam Chair, you're
Chair
still
Scheibel.
on mute.
Please go ahead.
Okay. Madam Chair, and good afternoon to you and the committee members. This is Attorney J.P. Kemp on behalf of the Nevada Justice Association here to speak about SB 107 and the amendments. The amendments seek to clarify that, in particular, common law wrongful termination claims that have been recognized by the Supreme Court of Nevada will be subject to a 2-year statute of limitations, but that time will be told during the time period which the any complaint or charge is pending before an administrative agency such as the Nevada Equal Rights Commission, so that a person does not have to file their common law retaliatory or wrongful discharge claim during the time that it's still being considered by the administrative agency. The idea is to get the timing to match up. And so, for example, with the Nevada Equal Rights Commission right to sue notice, they give someone 90 days to file a lawsuit after they are issued that right to sue notice. The amendment would provide 90 days plus a few days for mailing because those are sent out by mail, so that the timing would match up with the timing for filing the common law wrongful termination claim would match up with the timing for bringing the discrimination or retaliation claim that's recognized by the anti-discrimination statutes in Chapter 613. And so that's the purpose of the amendment. It will remain 2 years, but you will have a tolling time while those administrative charges or complaints are pending with administrative agencies.
All right, thank you so much. It looks like we do have a couple of questions. We will go to Senator Pickard first.
Thank you, Madam Chair, and Mr. Kemp, thank you for being on, and I appreciate our conversations offline. I just want to make sure that we have on the record for purposes, because this is something that's actually apparently contested fairly hotly in cases where there's a question about common law. We're not a common law state. We haven't generally adopted the common law, but where the Supreme Court has specifically, as you mentioned, adopted things like public policy, actions against public policy and a few other instances, that this mention of an action in tort for common law wrongful termination isn't intended to expand and adopt through the back door, through this statute of limitations Sorry, I was muted. I'm not sure how much of that got in. Can you hear me?
I think we heard most of it. It was just the
Okay.
very end that got cut
All right,
off.
all of a sudden I noticed my mute button was on and I hadn't turned it on. So anyway, I just want to make sure that we're clear that when we're talking about adding the words common law wrongful termination, we're not through the back door adopting the common law for all things employment, but we're just addressing those that have been adopted by the Supreme Court up to this point, and any that they may elect to in the future. But that this isn't a wholesale adoption of the common law. This is only to allow us to address those that are currently adopted, and then we're not moving to the implied contract, which would be a 3-year. Is that an accurate statement, or can you state it probably more eloquently than I can?
Chair, through you to Senator Pickard. This is J.P. Kemp for the record. Yeah, Senator Pickard. Yeah, let me put your mind at ease. All that SB 107 is a statute of limitations bill. It doesn't recognize any particular causes of actions or claims. It only identifies the time limits under which those claims can be brought in court. The common law claims that we're talking about, again, the Supreme Court of Nevada has, by common law, established the at-will employment doctrine, which means an employee can be fired for any reason or no reason at all, as long as that reason doesn't violate the law in some way. For example, if it was illegal discrimination on the basis of age, race, religion, national origin, gender, disability, or if it would violate common law public policy, strong public policy principles, and that's the case that we're talking about here. They've been recognized as common law claims by the Supreme Court of Nevada. And again, the reason it says common law is because they aren't recognized by statute by the legislature. These are claims that the court has created through its inherent common law powers to recognize claims that violate public policy. I also want to note that the Supreme Court of Nevada has been very clear that these exceptions to the at-will doctrine are very narrow and limited. It's only the ones that the court has expressly acknowledged. And so if SB 107 becomes law, it will apply to those that the court has recognized. But it also has the flexibility to show that in the future the court may recognize others, and those would be covered by SB 107 as well, and that's why we use the term, the common law wrongful termination claims. It's those that have been recognized by the Supreme Court of Nevada, in contrast to the ones that have been recognized and enacted by the legislature. So I hope I've answered your question.
Yes, I appreciate that. I'm going to dive a little bit deeper, but that satisfies for now. Thank you very much.
All right, I see a few other questions. Senator Hansen, go ahead.
Thanks, Chair Scheibel. Just a quick question. With this new law, if an employee sues an employer and the case is dismissed by the district court, under the new law, would they be able to then file another virtually identical claim against the employer? There's some verbiage in here that seems to indicate that, and I'm just kind of wondering. I doubt that's the intent. I just want to make sure we get on the record whether or not you can get one shot at the district court level, and you don't get to keep recycling the whole process.
Senator Hansen, to you through the chair. You were breaking up on me there a little bit, but if I understand the question, you were asking if somebody brought a claim and it was dismissed by the district court, would they be able to refile the claim? It sort of depends on how the district court addressed that. If they dismiss the case without prejudice, then a person could refile a claim. So, for example, if in their pleading they didn't specify things, they didn't cover all of their bases, all of the things that have to be included to state a valid claim, the court dismisses it without prejudice, they would be able to refile again as long as they're within the statute of limitations. Without prejudice outside the statute of limitations, the person would be barred from bringing the case back.
Okay, that's current practice now, isn't it? That's not something new with this law, correct?
No, the law would, this statute would not affect that law at all. It doesn't. There is a finite period which these claims are valid. So if you brought it on the very last day, and the court dismissed it without prejudice but without leave to amend, you would be basically stuck not being able to bring the claim back. But I would say most times, if especially a lot of these claims, because of companion federal claims, end up in federal court, and sometimes, or very often, the court will dismiss it without prejudice but with leave to amend. And if they give leave to amend, then you could go ahead and amend the claim because the case would not be closed out. But if it's just a dismissal without prejudice, the case is actually closed out at that point, but you could refile it if you did still have time to do so. I hope I've answered your question.
You did, and thoroughly. Thank you. Thank you, Madam Chair.
Absolutely. And we will go next to Senator Settlemyre.
Thank you, Chair. Building off of what Senator Hansen said, it does create a situation where currently, under current law, they wouldn't have the ability to bring up a discussion. And so by changing this law, I'm a little concerned because, again, currently right now you have a certain time frame under state and federal law that you generally keep your records for. So what will happen in these type of employment termination cases when we adjust this time frame? What happens to the employer if they don't keep those documents for this new extended period of time, which is somewhat unlimited because, again, we're tolling it for that period? And you get into a lawsuit, does this get into the he said, I said, she said type situation, or how does that work?
Senator, to you through the chair, I recognize the concern, but in these particular circumstances where somebody has brought a charge related to the termination of their employment or related to things that took place in their employment, the administrative agency is going to have given notice to the employer that the charge is pending, probably asked for the employer to provide documents or witness statements or information to respond to that administrative charge. So the employer is going to be fully aware of that, and they're going to have taken steps to preserve the evidence in the normal course of things, because they're going to have been given notice of the administrative agency charge or complaint. So I think that your concern is ameliorated because it's not as if the employer would have no idea that this would be coming at them out of the blue. They're going to have been given notice of this long before the full 2 years have gone by, even.
I appreciate that. Not sure if I could elaborate. I do have some concern, though, because you may be in a case with someone that has nothing related to the concept of termination, and then now magically you may have accidentally, I agree with you, it'd probably be best for an individual if you get into any argument with anyone to keep all information about that employee forever. But in the same respect, they may not have known it was anything to do with an employee termination, and then all of a sudden, several years down the line, it is. So I do think that my concerns aren't necessarily mitigated because of that. But I appreciate your answer, and thank you, Chair.
Absolutely. All right. Now that we have answered questions, is there a motion to amend and do pass?
So moved.
I have a motion from Senator Harris to amend and do pass. Do I have a second?
Second.
I have a second from Vice Chair Cannizzaro. Is there any discussion on the motion? Seeing none, will the Secretary please take the vote?
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre,
I'm going to be no at this time, but with a reservation.
Senator Hansen,
No with reservation.
Senator Pickard,
be a yes similarly with reservation to change.
Chair Scheibel.
I'm a yes. So with that, the motion carries, and we have voted to amend and do pass SB 107. I will assign the floor statement to the sponsor, Senator Orenshaw. And that brings us up to speed with all of our housekeeping or business other than bill hearings for today. And we have 2 bill hearings. I do want to let everybody here and everybody who's listening in understand that it is about 1:20 now. I will keep track of the time to try to allow for everybody to have their voices heard on these bills and to allow the committee ample time to ask questions. To that extent, you may also provide written comments or written testimony to the Senate Judiciary. We read all of those very thoroughly and appreciate your participation in that way. I'm not going to set time limits right now. I'm going to, like I said, keep an eye on the clock and keep you guys informed of how we're doing on time, because we do want to make sure that we give these bills thorough hearings and answer all of our questions and hear from everybody who has taken the time out of their day to call in and testify. But we also have other places that we have to be. So with that, I will open the hearing on SB 212, which will be presented to us by Senator Harris.
Thank you so much, Chair Scheibel and members of the committee. My name is Dallas Harris. I represent Senate District 11, which is in the southwest part of Clark County. I will do my best to be cognizant of time, but also thorough. So if you'll just indulge me for half a second, I'm going to share my screen. All right. Did I do it successfully? Cool, great. All right, let's go. So this bill essentially is about modernizing our use of force policies. I'm gonna talk a little bit about why we might want to do that, key use of force policies, level of force determinants, some changes that I have, and everyone should have an amendment in front of them, reporting of use of force, and just a quick summary on the back end. So while Metro has, instituted some great use of force reforms, it's in direct response to use of force incidents, officer-involved shootings, and death from officer-involved shootings. Las Vegas reported a 26% increase since 2017 and 18% increase last year alone, after seeing a 22% decrease in use of force incidents from 2015 to 2016. They are, however, increasing across the state. And they're becoming more deadly as fatalities from officer-involved shootings have nearly tripled. In 2020, 1 in 2 officer-involved shootings resulted in the death as compared to 1 in 5 in 2019. We have to work to decrease these incidences. Reforming when deadly force is used, when it's necessary, and improving the reporting of use of force incidents across Nevada is how we get there. Use of force is also a racial justice issue. Reno is the deadliest city for Black men at the hands of police in the United States, and Washoe County as a whole is equally as high. Unfortunately, as you can see on the chart, Nevada has 2 entities in the top 7 cities, as Las Vegas also kills Black men in police custody at rates higher than they would otherwise be killed. Police use of force should never be higher than the murder rate. We should expect our peace officers to preserve and protect, and to do so, we must modernize our approach to use of force, to understand the issues, report the data, provide alternative techniques, train officers, and create a culture where use of force is the absolute last result. And while cities are most often under fire, the research actually shows that nationally, more people are killed by police in the suburbs. That's why use of force changes are necessary statewide. More restrictive use of force policies do not limit what police officers can do. If an officer is in a situation where someone poses a threat of seriously bodily harm or death, they're allowed to use deadly force in response. However, there are many steps that officers can take before deadly force should even be a consideration, and the majority of incidents could be resolved using lesser force. Using deadly force because you can and feeling justified because it's in the arsenal shows a demonstrated lack of commitment to preserving life, a lack of training, or worse. There are several tried and true steps that can be implemented prior to use of any force, and it's important that we equip our law enforcement agencies with all of those tools. There are also long-term implications from frivolous and frequent use of unnecessary force. First, escalation is more likely if the mere presence of an officer indicates that use of force is not just a possibility, but a probability. 2, the public lacks trust in the people who are sworn to protect it. And finally, there is control. The point of a police instruction is for an officer to get their situation under control. The perception that officers will immediately resort to force adds additional tension to situations and puts passerby, witnesses, and others on edge. Campaign Zero has identified 8 critical use of force policies that can help to reduce use of force incidents resulting in violence. They include banning chokeholds and strangleholds, which has been done in Nevada with the passing of AB 3 during the 32nd special session. Requiring de-escalation of situations, requiring a warning before shooting, and exhausting all other alternatives before resorting to deadly force. They include a duty to intervene by police officers who witness unlawful police violence, which we also were able to accomplish in AB 3. There's a ban on shooting into moving vehicles, requiring use of force continuum be established and continually reinforced in training, as well as comprehensive reporting. Some Nevada police departments have embraced police reform, but it's imperative that all agencies are enacting the appropriate measures to keep Nevadans and officers safe. So the intent of SB 12 is to help modernize our use of force policy by strengthening it across the state and standardizing the expectations so that officers and people know what to expect regardless of jurisdiction. The first step is to ensure that all officers in Nevada assess a situation before resorting to a higher level of force. Las Vegas Metro Police Department has identified each force option with the level of control with increasing escalation responses, specific tactic, and weapons associated with the level. This helps officers make the right decisions using the right tools as the situation escalates. A use of force continuum can serve as a guideline to assessing and reacting to situations. Currently, the Reno Police Department does not use such a continuum. This bill addresses that by requiring officers to use de-escalation techniques and alternatives to higher levels of force. Section 2, paragraph 1 has the de-escalation techniques, which have been studied in many industries, including healthcare and education. As a first step in the use of force continuum, techniques can reduce stress, provide calm, and help officers maintain personal and situational control. They're effective in managing offender aggression, which is the key trigger to situational escalation and increased levels of control. Officers need to internalize the steps so that they can seamlessly execute them in the correct order when on duty. Creating a culture that celebrates the reduction of incidents of violence is necessary. All law enforcement agencies should be repeatedly trained in de-escalation techniques and utilize them prior to higher levels of force. If deadly force is necessary, officers are required to give a verbal warning, identifying themselves as peace officers, or through physical identification prior to using deadly force. Interestingly, most Americans believe that this is one of their rights, that a police officer must give you a warning before shooting. However, it's neither a right nor a consistent policy across law enforcement agencies in Nevada. 426 cities in the US require warning before shooting, and so should Nevada. This addition will simply modernize our policy to meet the expectations of communities and to ensure officers have reached the final step prior to the utilization of deadly force. Section 2, paragraphs B1 and 2. In terms of use of force, the statutes have been amended to include the level of force determinants here. First, officers may only use a level of force that's reasonable under the circumstances to bring an incident or person under control and safely accomplish a lawful purpose. Next, the level of force must be balanced against the level of force or resistance exhibited by the person. And then the use of force must be carefully controlled to the extent feasible. If a person flees into a public park, it's not considered to be reasonable for an officer to just start shooting into the crowd, putting innocent lives at risk in an effort to apprehend a subject. Additionally, this law seeks to impose policy and training around use of force with people who do not pose a threat of seriously bodily harm or death if the person's not armed with a deadly weapon and appears to the officer to be under 13 or over 70, physically frail, mentally impaired, pregnant, suffering from a behavioral health issue, or experiencing a medical emergency. Written policy and training will be required regarding the potential threat of someone with these listed characteristics, and that policy and training must reflect the best practices with respect to use of force on those persons. In response to the summer of 2020 and the events of January 6th at the Capitol, one thing rings clear. We need to revise policy to address police response and use of force when people are peacefully assembled. Section 4 of SB 12 amends the NRS to include restrictions on several non-lethal weapons. The first is restraint chairs. The use of restraint chairs has been outlawed in multiple states across the country. There's no viable reason to use the chair as it constricts blood flow and can cause severe injury and death. However, they are currently used in our systems, in juvenile settings, in mental health settings. And so what we've done is put some reasonable restrictions around their use. Following limitations have been added to the use of restraint chairs. They should only be used to restrain an individual that demonstrates obstructive, assaultive, or life-threatening resistance. A supervisor must authorize their use. A person placed in a restraint chair must remain under direct visual observation until screened by medical staff, and every 15 minutes after that. Medical staff must be notified when a restraint chair will be used. Oh, sorry about that. Medical staff should be notified when a restraint chair will be used and should conduct an initial assessment of the persons before it's used. The person should be assessed frequently, not to exceed 30 minutes, by a supervisor to evaluate that person's level of resistance and see if they can be removed from the chair. Restraint chairs will not be used to restrain pregnant persons physically. Persons should not be restrained for longer than 2 hours with additional approval from the supervisor. And restraint chairs should not be used to threaten inmates who are not otherwise demonstrating obstructive, assaultive, or life-threatening resistance. Taking these steps to limit the use of restraint chairs will decrease incidences that result from the use of restraint chairs significantly. Additionally, it'll allow departments to consider other techniques for restraint when restraint chairs are not an option. Peaceful demonstration is the core tenet of our democracy. Police officers should not assume that an assembled group is intended to do anything more than voice their dissent against injustices that they face. However, police response to demonstrations have often resulted in medical injury to groups who have assembled peacefully. Therefore, it's necessary to amend the statute to give more direction on the appropriate response. The first is to limit the use of kinetic energy projectiles like rubber bullets. Peace officers should not be indiscriminately discharging these into a crowd, nor should they intentionally target the projectiles at a person's head, pelvis, spine, or other vital areas. The purpose of using projectiles is to control the crowd or disperse the crowd. Therefore, firing them should be controlled and reasonable. The next change addresses the use of chemical agents. This bill restricts the use of chemical agents to an instance where an unlawful assembly has been declared. And the discharge should follow specific orders to disperse that have been heard and understood by the assembled group. This may mean having interpreters or other resources available to translate information into the language of the group. Also, the group must have a clear route of egress. If a crowd is ordered to disperse but's confined by police barriers or building, the officer must give the group space. And finally, officers should allow sufficient time to disperse once an order has been given before discharging a chemical agent. Final step in modernizing Nevada's statewide use of force policy is comprehensive reporting. None of Nevada's law enforcement agencies comply with the use of force policy that requires comprehensive reporting. We don't have the ability currently to put these into a statewide reporting database. Reporting across jurisdictions is currently fragmented and inconsistent. Washoe County reports race, but doesn't separate the types of use of force incidents. Metro reports incidents, but does not have any demographics about those involved. Henderson departments report substantial external complaints, substantiated external complaints of force. This bill would allow our police departments to centralize all of that information through the central repository and not add a bunch of additional work on their behalf, and it would make that information public. Standardized reporting is important so that everyone is reporting the same information in the same way so that recommendations on improving the statistics can be made. All law enforcement agencies need to collect data consistent with the National Use of Force Data Collection Standards from the FBI. In Section 3 of this bill, it requires that those departments participating in the DPS Uniform Reporting System report that information for analysis to DPS, and we ask the Attorney General to take a look at that and make recommendations to us, the legislature, to see how we can address any issues if we see so. In summary, Nevada has the opportunity to lead on police reform. Some cities have already started, but it's imperative that we strengthen our use of force policies to reduce incidents of police violence, address issues of other types of violence, help officers feel prepared to use other alternatives to deadly force, and use data to improve the systems of justice. SB 12 is our path to success for making Nevada a safer place to live, work, and thrive. And with your indulgence, Madam Chair, I'd now like to introduce the following speakers to provide additional expert testimony on use of force policies as described in 212. I have with us DeRay McKesson, co-founder of Campaign Zero, Sam Singyagwe, I hope I'm saying that right, and Katie Ryan.
Absolutely. Whatever order you would like them to go in, Senator Harris.
We're going to start with Mr. McKesson.
Hello, it is an honor to be here, and we are Campaign Zero. We have led on this work across the country, helping cities and states think about use of force policies differently. We started this in 2015, but the latest big push was around a campaign called 8 Can't Wait that began in June of last year. And since then, this is one of the biggest changes in police policy in American history. Katie will talk in a minute about the scope, and Sam will help us understand the research behind it and why this actually matters. But like Senator Harris said, this is an opportunity to actually do something that'll save people's lives. It is important that at the state level, that these changes happen so that it's not only the major departments, because what we find across the country is that most of the killings by police happen actually in suburban communities. They don't actually happen in cities. And that we want to put these rules in place to be preventative so that we don't have to only put them in place after bad things happen. So these are tried and true. We know that the research says, like Senator Harris has already said, that more restrictive use of force policies actually save people's lives. And Sam will help us understand better the landscape of what the data tells us around Nevada, and then helping tease out these specific policies and what the research says. So I'll turn it over to you, Sam, and then Katie.
Great. So if someone could help me view my video, that would be great. It says I can't. Okay, cool. Thank you. Hello, everyone. So my name is Sam Sinyangwe. As DeRay said, I work with Campaign Zero. Just wanted to provide an overview of some of the data around why these types of policy restrictions can make a difference. So, there has been a host of conversation over the past 6 or 7 years about police violence in this country and how it particularly impacts Black and Brown communities. What we have seen in looking at the research literature is almost 4 decades of research that has consistently found in city after city after city that places that had more restrictive use of force policies, places that, for example, banned officers from shooting at moving vehicles, banned things like chokeholds and strangleholds, required officers to use de-escalation and available alternatives to deadly force, and included comprehensive reporting around use of force as well, that those places had significantly fewer killings by police. And not only that, but they were also safer for officers as well. because officers weren't sort of rushing into situations using force when they could have created time and space and used de-escalation to prevent that sort of adversarial encounter in the first place. So we have seen, and Katie can talk about cities across the country that have begun to enact more restrictive policies beginning in June of last year. But we know that this is something that is particularly important for a state like Nevada, where you have 147 people who've been killed by the police from 2013 through 2020. The state has the 5th highest rate of fatal police violence in the United States among the 50 states. And in the context of those 147 incidents, only one case resulted in officers being charged with a crime, and those charges were later dropped. So very little accountability from the criminal justice system in terms of stepping in and holding officers accountable, which means we need to be thinking about preventative measures to prevent these incidents from happening in the first place. Use of force policies is one of those areas that has the strongest evidence of effectiveness and the most research that has been done over the years validating that more restrictions in this domain can actually save lives.
Thank you so much, Sam. And we'll turn it over to Katie Ryan if she wants to jump on.
Hello, everyone. If someone could also enable my video. Perfect. Great. Hello, everyone. Again, Katie Ryan from Campaign Zero. A lot of gratitude for the invitation to speak today. What I would like to do before sort of sharing the national landscape is to call out some of the specifics of Representative Harris's bill to illuminate the importance of why and how exactly you all can, as a state, employ more restrictive use of force policies to stop and reduce police violence against communities. The first is the component around requiring de-escalation, right? We often hear from police departments throughout the country that officers are trained in de-escalation strategies and tactics and learn how to use lesser means of force before resorting to deadly force. However, the expectation to use or implement that training isn't always codified into policy. And what we are asking the state of Nevada to do is to take de-escalation training and make sure that it is an expectation that officers use that training, in fact, when they are engaging with the public. Similarly, making sure that officers, when feasible and given the totality of the circumstances, give individuals an opportunity to comply with commands or verbal directions by also warning that the use of force is a possibility should they not comply. And to make sure that officers are required to adhere to a use of force continuum, that we are outlining various types of circumstances that officers might encounter, outlining what a proportional response would be, and then making sure that there are restrictions on weapon use, again, so that officers are not putting individuals or themselves in volatile, unnecessarily volatile situations by escalating a situation too quickly. I want to note that these are not necessarily earth-shattering policies, right? As Sam mentioned and DeRay mentioned, we have 40 years worth of research and analysis to substantiate that these types of policies actually reduce police violence. From our experience, and since the death of George Floyd in June of 2020, we know that 340 cities across the United States have adopted more restrictive use of force policies. That's just in the last 10 months. And that 13 states in the United States have adopted some level of statewide more restrictive use of policies. And we certainly want to support Nevada in being in line with those states who are showing their communities that they want to hold officers accountable and that they want to see more justice in policing, especially as it relates to Black and Brown communities. Thank you.
Thank you so much. And Chair Scheibel, again, with your indulgence, before I take questions, I just want to make one more comment. This bill is still a work in progress. I am still having plenty of discussions to make sure that we get it to a point where everyone feels that we're serving the community. And I have some concerns still to address, but I wanted to put that on the record. And I would invite the 8 Can't Wait team to hang on and maybe assist in answering some of these questions if they'd like. Thank you, Chair Scheibel.
Thank you, Senator Harris. And thank you to the 8 Can't Wait and Campaign Zero folks who have joined us today to help present the bill. And now you're going to get some great questions from the members of our committee. They never disappoint. So let's start with Senator Hansen.
Thank Chair Scheibel. First of all, I got to say that this was an incredibly one-sided, loaded presentation. And the fact that our law enforcement committee is going to be limited to 2 minutes to rebut some of these charges, I think is outrageous. Okay. So, I've been on this committee for 6 terms now, and that presentation and some of the accusations that were made absolutely should give a minimum of equal time to the Nevada law enforcement community to rebut. My question, though, is 3 people were presented to this committee as experts: D-Ray McKesson, Sam Singa-Yang Wee, and Katie Ryan. Would you all 3 tell me why are you experts in these fields? Are you guys professional criminologists, or, I mean, where are your credentials? I'd like to know you guys why are you experts?
Chair Scheibel, if I may, just very quickly before they jump in there, Senator Hansen, I'm sorry that the presentation offended you so much. I would like to let you know.
I'm not offended.
Okay, well, I want to let you know.
I'm not offended. I just think it's highly one-sided.
I want to let you know I've worked with law enforcement on this bill, and when we get to testimony, you will see that they are in support.
Really? And they agree with the statistics you show that Reno, Nevada is the highest? I'd like to know the actual numbers of Black people killed by the police in Reno, Nevada from 2013 to 2020, because I live in that community, and I know when they have had those sorts of killings, that the NAACP and all sorts of organizations are brought in to verify whether or not the cops actually use some sort of racial injustice in the motivations in the shootings. As I recall, there hasn't been even a single case. Well, you guys mentioned one for the state of Nevada. Perhaps that was in Reno. But in every single case that I'm aware of, they were considered justifiable shootings. Anyway, I'm sorry. I didn't mean to interrupt you, Senator Harris. Go ahead.
So we're happy to talk, and it's great to be here. So Campaign Zero, I was one of the original organizers in Ferguson in 2014, and once the protest ended, we were trying to figure out what are the structural things. So we actually manage the most comprehensive database of police violence in the United States. There are 3 databases of police violence. Remember, the federal government is not one of the 3 because only 40% of American police departments report to the federal government. The federal government does not release disaggregated data at the department level or the actual action type level. So the 3 databases are the Washington Post, Fatal Encounters, and ours, Mapping Police Violence. The Washington Post only codes on-duty killings that include a gun. So that means that George Floyd's not in their database because he was not killed with a gun, for instance. And they also code you as armed if you had anything in your hand at the time of death. So Tamir Rice would be coded as armed in their database. If you remember Botham was killed by a police officer when he was on his couch in the middle of the night. Amber Geiger, she was off duty when she killed him. So he is not in the database of the Washington Post. Fatal Encounters is the other big database. Fatal Encounters counts anybody who was killed in the presence of police. So that includes things like death by suicide. Our database, Mapping Police Violence, is the most cited database of police violence in the United States, and is the only database that is all on-duty, off-duty, all weapons, and is being used in a range of studies that Sam can talk about. So we manage that. We also manage the only database, the only public database, and the only database that exists at all, of use of force policies in the United States. So we are the leading experts around use of force. It's the only database, the only analysis of use of force policies that has ever existed. We manage it. We also manage the only database of police union contracts in the United States and the 21 states that have state level legislation around policing. We manage those. And the last campaign that we manage is a campaign around no-knock. So we are working in 50 cities and states as of today around banning no-knock raids in communities, and we lead that work, working with a team of researchers on all of our campaigns and a set of experts who additionally study these things. Happy to provide you with the research basis for this, which is all publicly available, and we also make all of the data publicly available. I'll ask Sam to respond to your questions about the Reno data that was presented.
DeRay, I also want to thank you for that, but that still isn't, because you manage a database, I'm not sure that raises you to an expert on criminality in the United States. You also mentioned your background started in Ferguson, Missouri. Isn't it true that Eric Holder, who was the Attorney General of the United States at that time, actually exonerated the police in that situation?
So, exonerated would not be the legal term that I would use. but the DOJ did not intervene in that case in the way that the protesters would have wanted. I can tell you my personal background. So I used to be, at the age of 30, the youngest chief of the Office of Human Capital in the history of the city of Baltimore school system. I taught, I've done a whole range of things professionally. I now work on police violence, but happy to provide the length of my resume, knowing the work around structural change. And again, I would push back on the idea that the only people who have a license to say about how officers can use force are the police. I don't believe that that's true. And I don't believe that it's true that the academy is the only people who can make decisions or provide input about how force is used in community. We believe that people in community actually should be a part of the process about deciding how force is used. And I would never, ever accept a definition of an expert that excludes people's lived reality from being a part of that expertise.
Well, D-Ray, I appreciate that. I'm actually a high school graduate myself, and so I don't claim to be an expert in all these fields as well. And I know for a fact that the police departments in the state of Nevada have worked aggressively to try to minimize any kind of violence. I actually chaired this committee at one time. So this is not a new issue to me as well. So I totally support the idea of reducing any kind of violence, not only by the police, but by the people that often assault the police. So, you know, it's a two-way street in many cases. So I actually support the concept behind this, to reduce and minimize the violence. But I think some of the things that were said, especially with the limited opportunities that the police departments would have to basically protect their own integrity and challenge some of these statements. I mean, I'm sorry, I don't think the Reno Police Department is the most racially motivated police department in the United States based on that, in my opinion, highly one-sided slide you showed, which placed them as the worst in the nation. So anyway, my apologies, Madam Chair. If the other two would like to tell me their credit, why they are experts in the field, I'd appreciate that as well.
Yeah, I would ask Senator Harris that Sam is allowed to talk about the data. You know, we stand by the data. The data is the data. We are not making up stats about Reno, and happy to provide you the backup. And Sam, if you could respond, that'd be great.
And that would actually be up to the chair,
Okay.
Chair Scheibel.
Absolutely. And yeah, I just kind of wanted to, I do want to thank all of you guys again for being here and for presenting to our committee. And I will leave it up to you guys. Senator Harris asked me first as the chair of the committee if I would allow the three of you to speak as experts on this topic. And I did approve your presence here as experts on this topic, being familiar with Campaign Zero's work and being familiar with 8 Can't Wait, and the three of you individually and all of the work that you have done in this field. I am, you know, I'm actually very honored that you would take the time to come to our little Nevada Judiciary Committee and help us understand the landscape in our own state. That being said, if you do want to expand on those qualifications, we would love to hear from you. And it sounds like we could probably focus in on Senator Hansen's main concern, which has to do with the data from Reno. And if you are able to and want to respond to that specifically, it is not, I will preface this with, it's not necessarily related to the bill. So I'm not going to require you guys to expand on that in committee if you'd rather follow up offline. But I'm also confident that you have the information at the ready. So if you would like to address it here and now, please go ahead.
So, you know, the other thing I'll say is, first of all, as DeRay said, all of our data is public, is online.
And if you could
as I said, there were 147 people who were killed by the, Samuel Sinyangwe, co-founder of Campaign Zero. So as I said, there were 147 people killed by police in Nevada during the time period 2013 through 2020. We've provided, I believe, a individualized list of all of those cases as well as the case outcomes. What we have found in looking at the data is that there are these patterns, not only in Nevada, but all across the country, where police violence is disproportionately impacting Black and brown communities, where some cities have higher rates of police violence than others, and in particular cities where there are rates that really are sort of outliers. What we have been able to do in disaggregating that data is point to particular places that have elevated rates of police violence within the state, and be happy to expound even more in depth, because one of the things that's important when we talk about this is we're working with the data that we're able to collect in an environment where the federal government is not collecting the data, which actually points to the importance of this bill. So we're talking about these 147 incidents across the state from 2013 to 2020. That includes fatal police violence only. We don't have good data on non-fatal police use of force, which often occurs much more frequently. And I think that is part of why this legislation, SB 212, is so important, to actually require departments to provide broader data on not only fatal use of force, where we already know that there are particular cities like Reno that have elevated rates, particularly against Black people, but also so we could understand the dynamics with regard to non-fatal force as well. So I think that this is, what the data can tell us, even the limited data we're able to obtain, despite all of the limitations, is that number one, Nevada has the 5th highest rate in the United States of killings by police. That those killings by police are concentrated in particular cities and by particular agencies that should get a second look by the state and by city legislators. And that there's a whole host of additional data that we don't have access to, that we wish we had access to, that could provide us greater context in terms of where interventions are needed. So I think all of that is the purview of this conversation and why this legislation is actually really important.
Sam, I appreciate that, but what is the actual number for Reno from 2013 to 2020? I mean, was it 1, 2, 10? How many Black people were murdered or killed by the Reno Police Department? I'd like that actual physical number.
We'd be happy to send you the actual raw data case by case.
You don't have it right now in front of you?
The numbers are all on the website. I mean, you can go there and disaggregate.
I know, you're the guy making the presentation.
No, we'll send you the number. It's not a secret. We'll send you the number.
Thank
we
you.
don't have the spreadsheets open in front of us. You are correct, Senator, but we will send you the numbers.
It's a public spreadsheet, and yeah.
All right. We will move next to Senator Pickard.
Thank you, Chair Scheibel. I will say I'm impressed. I think, I wish I had a small degree of the ability that I see from Mr. Sinyangwe and Mr. McKesson in terms of their ability to articulate and communicate. I wish I had that talent. Mine tend to be a little more mundane, I suppose. My questions are really about first, the presentation suggested that we're not using de-escalation techniques in Nevada. Do we know what is there data that shows what they do? I mean, I've been under the impression that law enforcement officers universally try first to de-escalate, but can you tell me what the data shows in terms of how few de-escalation attempts were made?
And if I can, very quickly, Chair Scheibel, to Senator Pickard through you.
If you could state your name for the record.
This is Senator Harris. Senator Pickard, I want everyone to keep in mind that this is not an accusatory bill. This is a bill about taking the best practices and putting them into statute to ensure that it is uniform across the state. So this is not to say, hey, you, Reno, you're a bad guy, and we're coming after you. This is to say we have learned a lot over the course of 40 years about what type of techniques work and what the best policies are. Let's go ahead and codify them and make sure they're uniform across the state. And so, I don't know if my colleagues from Campaign Zero have the exact numbers, but I want you to understand that this is not about Officer X, who we know didn't use de-escalation techniques. This is about taking the best practices that we can all agree on, putting them into policies so that these things don't happen moving forward.
Yeah, so I just briefly say that police departments actually do not record de-escalation attempts. That's not a thing that police departments record. So what the bill would do, it require de-escalation. So around the country, what we see is the police departments will say, well, we train on de-escalation, right? Which is true. There are very few police departments across the country that do not train on de-escalation. That does not mean that de-escalation is required in an actual instance. This would require de-escalation.
And to the point of the data around how often officers are de-escalating, as DeRay said, there are very few police departments that even report de-escalation as a reportable type of sort of force alternative. Chula Vista Police Department in California is one of the ones that does. So if you're interested in seeing how that works, definitely look at them. I think more broadly, there is some data on how often police officers use alternatives to lethal force, particularly looking at less lethal force and other levels of force. in lieu of deadly force. So for example, in California, under the URSIS program, the Use of Force Data Collection Program, that's been in place there for several years due to state legislation, they regularly publish data on every police shooting, both fatal and non-fatal in the state, as well as requiring every agency that reports that data to specify what types of other force did they use in the context of that incident and what was the order in which they used the force. So we're actually able to see, like, did the police attempt to use a taser before they escalated to shooting? Did the police attempt to use other forms of physical force before they escalated to shooting? What we can say when we look at that data, again, there are a few years of data now, 2016, 17, and 18 now. And in that database, more than 80% of all police shootings in the state, the police reported using no other type of force other than deadly force. So they did not attempt to use less lethal force before using deadly force in at least 80% of shootings. There's another 10% or so in which there are issues with the order in which they report the shooting. So we've actually had to do work to figure out, using the police statements, media reports, and other information, where they didn't report in order, what the order was in which they used it in. And in some of those cases as well, they may have used another form of force after they used deadly force. So between 80 and 85% of cases in California involve an officer that shot somebody without using a lesser means of force first. That may change now because of state legislation that restricted their deadly force standard that passed recently. But those are the types of restrictions that can be really impactful, as SB 212 would be, because it is actually rare for officers to use less lethal alternatives prior to deadly force. And this bill would emphasize the use of those tools instead.
All right, and I appreciate that, and I apologize. I should have been clear that I was looking for data for Nevada. You know, the policing all over the country is different in every single jurisdiction, although there are obviously commonalities, but I'm interested in the Nevada data because presumably the statute is applied only in Nevada. So I'm trying to make sure I understand how this is changing the status quo. You know, there were suggestions in the presentation that I thought we were saying that police aren't using de-escalation. We're using these restraint chairs. I mean, this is the first time I've ever heard that the restraint chairs were killing people. Not to say they're not, I just haven't heard about it. But there are a number of things in here that are shall nots. You know, I can envision instances where restraint would be necessary to protect everyone around them and potentially the individual. I'm appreciative that the amendment, which I didn't have a chance to review before it was given to me right before the hearing, addresses some of that. But I'm trying to get to the data and trying to figure out what is the actual status quo today. What are we trying to fix? I kind of reject the idea that we just want to put everything, you know, all good practices into statute because that's the purpose of regulation. And, you know, I reject the idea that if you don't, even if you train for it, well, it doesn't necessarily apply because that's what the standard that the officers are held to in any kind of litigation. So with that as a backdrop, I'm trying to understand what is it that we're not doing in Nevada that this bill fixes?
Senator, just as a point of clarification, the training is not what they're held to from a disciplinary standard. So officers get trained on a host of things.
Gotta state your name when you speak.
Say your name.
Ray McKesson. So when officers break policy, for instance, that is you can be disciplined for that. That's a process. But merely that officers are trained on it in very few places is that actually something that leads to a discipline or is a part of a discipline matrix or is used in any of those processes. So that just, you know, we've seen this in cities far and wide. There are some cities.
But in Nevada.
Yeah, so in Nevada, there are police departments that have recently, after June, we worked with them and they changed it to require de-escalation. That is a good thing. That is not the law, so they could change it tomorrow back to not require de-escalation and could just say they train on de-escalation. The law will prevent people from going back and forth. But again, it is not my understanding in Nevada that simply being trained on it is the same thing as it being an actual policy and enforceable rule.
And Chair Scheibel, if I may, you know, Senator Pickard as you know, regulations are great. I am a fan of pushing things down to a regulatory body. However, there doesn't exist one for police departments across the state. And so this is not regulations apply all the way statewide. What we have are policies and procedures that are kind of police department specific. So, we don't really have that same kind of ability to require all police departments to do something, but maybe through regulation.
That's a good point. I appreciate that.
And I'll also just say very quickly, I think it's really important that the committee understand this bill is the product of work, months and months of work with every group you can think of, not just community members, right? But Las Vegas Metro, the Sheriff's Association, Nevada Police Union. They have been at the table from the beginning. So you're looking at a product that has been vetted through multiple groups, language that has kind of evolved over time to get where we are today. This was not something that I just kind of came up with and thought, well, this is what we should do, and just put it out there.
And I certainly appreciate that. This does look like, and particularly when we look at the amendment, it looks like there's been a lot of iterations and discussions that have gone into it, and I appreciate that. I'm just, and I wouldn't be surprised if in today's political environment, police officers or the organizations across the state come in and support at least of the amended version because, they're kind of behind the eight ball. But, my initial impulse, particularly after the presentation, may not have been as strong as Senator Harrison or Senator Hansen's, but I did kind of react a little bit and think, it's pretty accusatory. The presentation was such that it sounded like, police officers, we're stopping short of a defund police argument, but it sounded like, these are our bad guys, and for Pete's sake, these guys keep us safe. And they're the ones who run toward the danger instead of away from it. And I think they deserve a great deal of respect for that. And so what I'm trying to do is get my arms around what are the differences that this bill is going to fix? What's happening that needs to stop that this bill is going to fix? And things like de-escalation, I'm quite confident that police officers throughout the state try first to de-escalate the issue. And I disagree that a litigation standard would not, or a litigation would not look at the standard of training as a baseline for liability. That's universal in litigation. So I'm concerned that we're basing this on national data instead of Nevada data without understanding the context. And that's what I'm trying to understand. Give me the context. What is this bill fixing that we're not doing?
I'm going to jump in for a second and say that I think that Senator Pickard's question to Senator Harris and the rest of the panel is, what does this bill change about our current practices, which I think has already been answered. I will give you guys another opportunity to answer it, and then let's move on because I see that pretty much every member of the committee has questions.
Thank you, Your Honor.
Yeah, just as a point of clarification, is that when we look at litigation number,
say your name, please.
This is DeRay McKesson, is that very few officers are ever prosecuted or charged around force. This would mostly be an administrative issue, and it would be administrative issues are almost always because of a policy. So if the policy does not say it, in our experience, it is not likely that there will be any discipline. There are some of the big agencies in Nevada actually in the past year have changed their policies, which is a very good thing, to require de-escalation and to do some other things, because they also understand that making it a policy actually makes this a hard and fast rule, and administrative consequences are normally the only consequences, if any, that officers face when they violate something. The training actually is not enough. So around litigation, very few officers are ever through the litigation process around use of force.
All right, thank you. With that, we will move on to questions from Senator Orenshaw.
Thank you, Chair, and thank you, Senator Harris, for bringing the bill. My question for either Ms. Ryan or Mr. McKesson or Mr. Sinyangwe is, in other states that have amended their state statutes on use of force in a similar manner to this, has there been less violent incidents when there's contact between police and citizens? Have we seen, I think we all agree, whether, regardless of our party or our feelings, that we'd like to see, whenever there's contact between police and our citizens, that there not be violence. And I just wonder if there's any data in your database for states that have gone and adopted reforms similar to this, that there's been the outcome we've hoped for, that there's been less violent contacts.
Sam?
So this is Sam Sinyangwe with Campaign Zero. It's a great question. The short answer is not at the state level, but yes, at the local level. So because this is relatively new at the state level, as Dre said, we've seen over a dozen states adopt more restrictive deadly force and other use of force standards in the past year. And so because so much of that movement has happened so quickly, we don't yet have the post data coming in so that we can understand the exact difference in use of force over that time period. What we do have and what we have tracked and other researchers across the country have tracked are cities that have implemented more restrictive use of force policies and the impact that has. We mentioned the study that we conducted with the 100 largest cities in the country. There are additional studies that have been conducted, for example, most recently in Seattle, looking at the decline in use of force following the adoption of a more restrictive use of force policy and a set of other accountability measures following the DOJ intervention and consent decree there. What they tracked was not only did use of force overall decline, but officers actually were safer as well following the adoption of those restrictive use of force standards. Those are similar standards to what is in 212, requiring de-escalation, alternatives to deadly force, banning shooting at moving vehicles, more comprehensive reporting, et cetera. There have been a host of cities that have seen declines in deadly force following the implementation of more restrictive use of force policies. I mentioned the 40 years of research. That research began actually in the 70s with a criminologist named James Fife, who first looked at the NYPD's adoption of a set of restrictive use of force policies that banned shooting at moving vehicles and required officers to use alternatives to deadly force whenever possible, and tracked a substantial decline in fatal police violence following the adoption of those policies. Since then, researchers have found similar effects in a range of cities from Columbus to Memphis to Philadelphia. In Philadelphia, researchers actually looked at what happens when they lift a restrictive policy. So in Philadelphia in the 80s, they adopted a more restrictive use of force standard for a few years under one police chief. Deadly force went down. Then that policy was repealed and deadly force shot right back up. So happy to provide sort of the overall review of the literature on this area. It is one of the most well-studied policy areas within the broader sort of police reform ecosystem out there right now. And again, now that many states are beginning to take action, we will have better data on the state level very soon.
Thank you. It's good to hear that there's been that positive outcome at the local level. Thank you, Mr. Sinyangwe. Thank you, Chair.
Thank you. We'll next go to Senator Settlemyre.
Madam Chair, we always get into discussion about who's unmuting each other. I'm used to unmuting my own, but not having the chair choose when I can speak and when I can't. So I guess we're gonna have to continue to figure that out. To the presenters, welcome to the state of Nevada. I appreciate your information. If you could do me a favor and send me or the whole committee, if the chair is okay with it, any specific information to the state of Nevada, and especially anything you might have that's broken down by county, so I can take an examination of the counties that I represent, since I do not represent Washoe County, which is the Reno-Sparks area, or do I represent Clark County in that respect? I represent 4 counties that are not in that contingent. So if you have any specific information you could send, I'd be appreciative to look at that information. To the sponsor of the bill, I was going to ask real quick, is this, so in other words, this is just stating that it shouldn't be your go-to thing, right? You should not think about escalating or, in that respect, this is not the go-to. But if an individual is in fear of their life, they have the right to automatically go to that, correct?
Senator Settlemyre, to you, Chair Scheibel, to you. Wait, nope, Senator Settlemyre, to you through Chair Scheibel. That's it.
You can go, Joe.
Senator Settlemyre, I think everyone has to remember we all have the right to protect our life, police officer or not. And so if someone's using deadly force against you, you already have the right to use deadly force. And that applies to every citizen actually walking down the street today. This bill would not change that.
So in that respect, if deadly force was immediately actionable, and I'm thinking of a recent situation in Douglas County where Officer Lenz was shot in the face through the car window of the individual who's being pulled over, just automatically shot him right through his own car and shot him right in the jaw. And the other officers automatically returned fire. That person doesn't have to fill out any of these reports, right? Because, I mean, right off the bat, the use of deadly force was authorized.
Well, Senator Settlemyer, I'll point you to two things in the amendment. One, in section 2, subsection 1, paragraph A, if it is possible to do so safely, right? We're putting that constraint around it. In the same subsection, but paragraph B, objectively reasonable under the circumstance. And so I think what you're just discussing here, where your partner's just been shot in the face, that leaves plenty of room for an officer to act within the totality of the circumstances to keep themselves safe and the public around them.
So in that respect, though, it says that will they have to then file the report pertaining to that information? Because, I mean, clearly it was lawful, so why should they even have to file a report? Because I think that skews the data.
So, Senator Settlemyer, it's not about the filing of a report. We're just collecting use of force incidents for kind of general reporting. This is something Las Vegas Metro already does. They have all their use of force incidents from 2014 to 2019, a nice, beautiful report that they put online. This is not about creating additional paperwork, but just capturing how often these things happen and who was harmed and what scenarios this was under. It is something a couple of our departments are already doing, just not all.
Appreciate that, Senator Harris. I guess the last thing I leave with is that if we have the officers, indicating how they went about trying to de-escalate the situation, would it not also be pertinent to make sure that they write in the report or somebody else writes in the report about how the person they pulled over de-escalated the situation also?
Not quite sure I understand your question, but I'm more than happy to talk to you about what fields should be in the use of force database. I think what you're speaking to, the resistance that you get from the other person, is a factor in what type of force the officer should use, but that data is not currently collected.
I appreciate that, Senator Harrison. I guess that's exactly where I'm at. Shouldn't we also make sure that somehow it's indicated how the person that was in the situation, Mr. Lenz, how that individual did not do anything to de-escalate the situation themselves? I mean, when I was a kid, my dad taught me the first thing you do when you get pulled over is leave your hands firmly on the wheel so that the officer doesn't think you're trying to grab something, and you be as respectful as you can and things of that nature so that they don't get you in trouble. But then again, when I had my driver's license, originally I was 5'2" and 110 pounds. So the police very much liked to pull me over because they assumed I stole my dad's truck.
Understood. Happy to have some further discussions about what data we're capturing and how we could even capture that data.
Thank you.
All
Thank you, Chair.
Absolutely. We will now go to Majority Leader Cannizzaro for questions.
Thank you, Chair Scheibel. And I guess I wanted to kind of preface this with a bit of a statement. I first want to thank Senator Harris for not only bringing this bill forward, but for working on it, for reaching out to law enforcement. I know there's still a lot of work to be done and probably some other folks to be spoken with to make sure that we get this policy right. And I do appreciate her work in that space. And I will also say that as someone, because it was sort of mentioned earlier in the hearing, as someone who is a member of law enforcement in my day job, who has done this for a decade, who works with law enforcement officers across the state on a daily basis, and who has a sister-in-law who is in fact an officer, I would be probably the first person to tell you that there are so many amazing officers in our police departments who really are trying to do the right thing, who do the right thing in really tough circumstances. And we have seen those instances, over and over again. We also know that there is, I think, a duty on all of us as legislators and as a community to make sure that the policies that we have in place, the laws that we have in place, give faith to the community that that is exactly who is out there working in law enforcement. I have faith that that is the case. I work with a lot of really wonderful officers and a lot of really dedicated and wonderful detectives who do a great job, and who I am proud to work with every single day. But I also think that as legislators and as members of the community, we have to make sure that whatever we are asking of our law enforcement agency, we can also say to the community, you can trust that if a police officer shows up, you're going to be treated fairly, and that situation is going to be appropriately handled. And I think that this is a good step in that direction. So I think sometimes I have a unique perspective in that way, in recognizing that there is room to say we can hold police officers accountable. I don't think officers are afraid to be held accountable when they are doing their jobs properly. And I also know that we have a lot of really great officers, but what we should be doing is putting into place policy that does make sense, that can hold those who don't fall in that definition accountable, and where the public can look and say, hey, we have a lot of faith that these folks who we are entrusting to keep our community safe, that's exactly what they are doing. Because as was mentioned, I 100% agree with, these are the folks who run into really dangerous situations. And if you've ever been the victim of a crime, if you've ever had to speak to a victim of a crime, or if you've ever had to speak to a family of the victim of a crime, which I spend most of my day job doing, and is in large part why I do what I do, you know that that's exactly what they expect from the officers. And when they show up and do that, that can be life-saving. And we have to be able to have that. And so I just wanted to, I guess, outlay that, because I do think we have a lot of really good law enforcement in this state. And what I sort of see this bill as is a way to sort of centralize and uniformly apply what we believe to be best practices in terms of de-escalation and dealing with the public. And so I guess I wanted to kind of preface that, and I appreciate being able to just take a point of privilege on that, because I do come at this with, I think, just a little bit of a different perspective. So I want to talk a little bit about the language in the bill that references de-escalation. And Senator Harris, you brought up sort of that graphic that shows the continuum of de-escalation. What I want to be clear, at least with respect to the language in the bill on, this de-escalation, as I'm reading it here, is something that we, of course, want officers in police departments, law enforcement agencies to teach. We want their officers to have training in that, and we want them to actually use it in the field. When I'm looking at this language, and I just want to make sure we're clear on this, that may vary based upon the incident and the individual circumstances that present themselves to that officer.
That is correct. That is my intention. I want police departments to ensure that their police officers are safe. I want police officers to continue to be able to keep themselves safe. I'm simply asking that they use those de-escalation techniques before higher levels of force, if it's feasible and safe for them to do so.
And that's how I am reading this as well. And so I just have maybe a couple of hypotheticals to make sure we can kind of parse this out, if you will, and if you'll indulge me a little, Senator Harris. So if we have an instance where an officer comes upon a scene, and let's say, for example, there is someone who is in the process of stabbing a victim, and doesn't seem willing to stop even upon the arrival of police presence. If that officer is not engaging in more de-escalation techniques than, say, identifying themselves and saying, hey, police, stop, that person doesn't stop. Under this bill, that officer may have the right to use deadly force in a situation like that, where someone is clearly being injured.
That is correct. Not only do officers have the ability to protect themselves, but also third parties.
No, and I appreciate that. And I know, there are officers that maybe have use of either a taser, or sometimes some of the less than lethal ammunition, or other types of non-lethal force. If they are attempting to use that force, but it is ineffective and someone is armed, that would still be a situation where, under this language, the use of deadly force may be appropriate.
That is correct, Vice Chair Canizaro. And I'll also note that while it requires an officer to identify themselves, they can also do so just simply by being in uniform. And so they are authorized to go ahead and do what they need to do.
Okay. And then obviously we want to make sure that de-escalation is happening on part of the officers. And I want to follow up on Senator Settlemyer's question. I think it's an important point, although I'm not sure where it would fit into necessarily statutory language and placing a burden on an individual to de-escalate if police arrive. But would that be a factor that would be considered when determining whether or not the use of force is objectively reasonable?
Thank you for the question, Vice Chair Canizaro. It would be, and I'll point you to Section 2, subsection 1, paragraph B, subparagraph 1. I don't know if I've ever gone down that far. Must be balanced against the level of force or resistance exhibited by the person. And so that is a factor that officers will take into consideration.
I wanted to next move just to the pieces of the bill that deal with, and I want to make sure that I've got this correct as well, because one of the difficult things that kind of came to mind as I was reading through it is where we're talking about someone who is, you have a list here of individuals who may appear, who are or appear to be under the age of 13, over the age of 70, physically frail, mentally or physically disabled, pregnant, suffering from a mental or behavioral health issue, experiencing a medical emergency, so on and so forth. I will say that falling into at least one of those categories as of recent, have definitely encountered the comment, well, you don't look too pregnant, so are you sure you are? What happens where, you're talking about asking an officer to sort of make that judgment call, right? Or you see someone who may look young, but they're actually a little bit older. And I think Senator Settlemeyer mentioned he may have fallen into that category at some point. Or someone who is older, but doesn't necessarily appear older. How are we balancing that sort of should have known with how it is that sometimes folks may not appear to fall into one of those categories, and how would that play with respect to an officer's approach to a particular situation?
Thank you for the question, Vice Chair Canizaro. I think you're hitting on why we're allowing police departments to adopt a written policy on how to deal with these persons, to require the training. My guess is if someone appears 10 and they're not armed with a deadly weapon, they likely do not pose a threat of serious bodily harm, but we're going to allow police departments to come up with policies and the best training and procedures on how to address this. I think you're hitting on another important point here, which is why I have appears or is known. Now, of course, there will be scenarios that don't fit into the either of those categories, and that's why we have an and here. And so if it doesn't appear or the officer doesn't know, there should be no expectation that officers be experts at identifying pregnant women.
That's fair. I don't know that I'm an expert yet, so TBD. I think that rounds out some of my questions, and I definitely appreciate this, and I think it really is incumbent upon us to make sure that folks can trust in law enforcement, and that we can trust in them. And I know we can, because I know we have a lot of really great folks working out there. So I just appreciate your work on this bill, and looking forward to seeing where we end up here. Thank you, and thank you, Chair Scheibel.
Absolutely, thank you. And I just have one question, Senator Harris, that I want to make sure I'm understanding, because in the language of the bill, we don't see written out with the de-escalation and also with the use of force. I think you had a great chart, the continuum, which I believe came from Metro, at least I know that Metro has used it, and it's a fantastic resource to explain how you might get from the least use of force possible to the greatest, which would be deadly use of force. But in the middle, it can be different for different officers. And so, an example that I've seen often are officers who have my body type, smaller women, and they're still interacting with people who are threatening our community, who may be larger, faster, stronger. And so I think that the reason that we don't see that, first you use a verbal warning and then you can go hands-on and then you can go to a baton and then you can go to X, Y, or Z, is that because the use of force is somewhat personal to the officers and we're trusting them to utilize their best judgment in the situation. And we know that we can't account for every single one of those situations. And so for a small female officer who is responding to a large group, that might be different from what we would expect of a large male officer who was trying to take into custody someone my size.
That is absolutely correct, Chair Scheibel. One thing I did not want to do in this bill is be overly prescriptive. And so I've really tried to walk the line of putting into place best practices, but also allowing police departments and officers to take different scenarios into consideration and also feel like they can keep themselves safe.
Excellent, thank you. With that, I don't see any other questions, and I think we all ask questions of you. So thank you again for your time and attention. We are going to move to testimony and support. I understand there is at least one person who is currently on the Zoom who is in support, and that is because she's presenting the next bill with me. So this is merely a administrative coincidence, but I would like to let her testify first in support. Again, not because she's my favorite, but because of the logistical coincidence here. Ms. Wellborn, are you there and do you want to testify? You will still have,
here.
All right, you will have the same 2-minute limit that everybody else has, and you may begin.
Thank you, Chair Scheibel. Holly Wellborn, Policy Director for the ACLU of Nevada. For the record, thank you, Senator Harris, for championing this bill and bringing it forward and moving us toward establishing a statewide use of force standard. It is desperately needed in this state, just as the individuals who came and presented to you with you today demonstrated. We are grateful to you for being here. There is work to be done on this bill. I won't say that we love the sections on restraint chairs and that we're confident that it's going to save lives as written, but we are willing to continue working with Senator Harris on that. We also believe the bill reads that if you're walking away from a protest, you could still be shot with a projectile, but we will get there, and I'm confident we will get there. I do want to make it abundantly clear, however, and clear up the record. I am a member of the Chiefs Impact Panel in Reno. The Impact Panel has no power or authority to make a determination on whether or not a use of force incident is justified. That is a determination that is made by the district attorney. I can attest to that for every member of that committee, that we are there largely symbolically. There's no citizen review board that has any power or authority to assist the district attorney's office in making that determination. That's something that we should look at changing in the future, but no, we have no authority to do that. I want to make that abundantly clear on the record today. Thank you, Senator Harris. We look forward to working with you on additional language, and thank you to the presenters who were here today. Thanks.
Thank you for your testimony. I understand we have one more person on Zoom, Crystal Folashad, who is also here to testify in support, and you will have 2 minutes. You may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Crystal Folashad, and I'm a second-year law student at the Boyd School of Law. And today I'm here to testify in support of SB 212. First, I would like to thank Senator Harris for bringing this bill forward. This bill is a step towards addressing police practices. I would like to highly emphasize that this is not where the conversation surrounding police use of force shall end. This is not a discussion that just comes and goes based on the current social climate. As many of us are aware of the events that occurred over the summer of 2020, specifically the death of George Floyd, being in a pandemic has made it possible for more people to be aware of this issue, but unfortunately it did not start there. Police use of force has been something to affect communities, especially communities of color, for decades. The number one goal of officers should be to protect and preserve dignity of human life. Additionally, accountability, transparency are crucial when considering public perception of police practices and integrity. I strongly urge you all not to let the conversation stop from flowing and to support SB 212. Thank you.
Thank you so much. And with that, we will move to the phone lines for testimony in support of SB 212. As a reminder, you have 2 minutes to speak. That is a maximum, not a minimum. Please feel free to indicate your support for what a previous testifier said. You can say ditto, me too, I agree. And with that,
Madam Chair, before you go to the calls, are we going to be allowed to ask any questions? Like, I would love to have asked Holly a little bit more about her experiences on that board she mentioned. Any possibility for any questioning of any of these people calling in, pro or con?
I will tell you what, Senator Hansen, we're not going to do that today during the hearing because they are calling in simply in support, neutral, or opposition. However, I would be happy to discuss with you and the sponsor of the bill facilitating another meeting in a less formal setting, a kind of town hall or a conference call to ask those kinds of questions.
Well, thank you, Chair. I would say that I hope we get back to a little more normal kind of hearings because traditionally we've always been able to ask questions of the people that come in. Thank you.
I'm not sure that we have always done that, but I am happy to accommodate the sharing of information in this committee. So for now, we will go to the phones for testimony in support.
Thank you, Chair Scheibel. To testify in support on Senate Bill 212, please press *9 now to take your place in the queue. Once again, to provide support testimony on Senate Bill 212, please press *9 now to take your place in the queue. Caller with the last 3 digits, 556, please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Anne Marie Grant, ANNEMARIE-GRANT. I am in support of this bill moving forward in hopes that some of the language can be tweaked during future discussions. I support it moving forward currently because there has to be some type of guidelines in place if we aren't prohibiting the use of restraint chairs in their entirety. It was disheartening to see the language prohibiting the use of restraint chairs in its entirety was removed. As someone whose brother was asphyxiated to death in another torture device used incorrectly and negligently by law enforcement in Washoe County, the RIP hobble restraint, I understand the consequences of using these devices on community members in crisis. The hobble was used to hogtie my brother, who on every single page of the manual states never used to hogtie a human being. Prohibiting the use of restraint chairs is vital in preserving the sanctity of life. Countless people have died in restraint chairs at jails and prisons. These torture devices, as I believe them to be, have claimed numerous loved ones' lives. Nicholas Farrow was 36 years old, a father and a husband, when he was asphyxiated to death on 3/31 at Clark County Detention Center in Nevada. Nick died within 75 seconds of being placed in the chair as deputies pushed his head down into his knees to adjust the handcuffs. I'd like to remind you all that these chairs are being used in jails, a contained environment with plenty of staff available to assist, not in some wild, uncontrolled environment. Checks every 15 minutes is too long. Nick was killed in less than a minute and a half while being in a restraint chair. Respiratory issues aren't going to wait 15 minutes to occur if they're going to happen. Brain damage begins within 4 minutes of brain deprivation. What is law enforcement's definition of evaluate? A visual look at a person isn't sufficient. A verbal conversation should be had with the person in the torture device. Constant supervision should be the requirement. Why is it too much to demand law enforcement fulfill their 8th Amendment constitutional obligation to community members? It's care in custody, not kill in custody.
2 minutes,
I ask what law enforcement's definition of threatening is language. That language is vague. If someone is only
Please wrap up. You've reached 2 minutes.
Thank you, Chair. If you've recently joined our call this afternoon, we're currently on support testimony for Senate Bill 212. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, thank you. I'm Chuck Callaway, Callaway, Director of Intergovernmental Services for the Las Vegas Metropolitan Police Department. I'm here in support of the bill. I appreciate all the work that Senator Harris has done reaching out with us and communicating on the bill. And much of what's in this bill is already in our policies and procedures. So out of the spirit of compromise, I am in support with the amendments, with the proposed amendments. I do take exception to some of the statistics that were given during the presentation, and I encourage the members of the committee to go to lvmpd.com and pull up our 5-year statistical use of force report, which is on the website, and other information related to our use of force policies. LVMPD has been engaged in collaborative reform for well over a decade. We were one of the first agencies to implement body cameras in 2013. We worked in a collaborative reform process with the Department of Justice and completed 75 recommendations that the Department of Justice COPS office had recommended. We are constantly reviewing and updating our use of force policy. We have collaboration with outside entities and the community to establish best practices in our policy. We were one of the first agencies to have a duty to intervene, a duty to provide medical attention and to put someone in a recovery position. First agency that I'm aware of to have a sanctity of life in our policy, and de-escalation in our policy. We removed the LVNR from our policy before AB3 last legislative session. And to just put some things in context very quickly, you know, in Clark County, our population has continued to increase. Prior to the pandemic, we have over 43 million tourists a year. We've seen an uptick in violent crime, and our officers handle 1.5 million calls for service on average a year, plus hundreds and thousands of self-initiated stops. And last year, in 2020, we had 19 officer-involved shootings, 10 of which were fatal. To one of the questions asked by the committee members, 4 of those 19 individuals were black. All of the individuals that were involved in officer-involved shootings were armed last year. I'm sorry.
Thank you.
Thank you, Chair. Once again, if
And I
you've
would
recently
encourage
joined
you,
our...
just like anybody else, to submit any additional comments in writing to the Senate Judiciary Committee, and we do read those. Thank you.
Thank you, Chair. I apologize for interrupting. If you recently joined our call this afternoon, we're currently on support testimony for Senate Bill 2112. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last 3 digits, 936. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, everyone. My name is Jamila Lewis, spelled Jameeelah, last name Lewis, Lewis. I am a community activist here in the state of Nevada, but also I am a native and a local constituent. I want to thank everyone who spoke in support before me, but most specifically, I want to share a little testimony for you all. I'm one of the protesters who was arrested the very first day of the protest here in Las Vegas, Nevada. I was slammed to the ground. I was told to stop resisting even though I wasn't moving. I was put in zip ties, handcuffs. I had snipers at my face. My stuff was thrown, and I was in a dress. Of no threat, couldn't have been a threat, I wasn't armed, but at that moment, I was definitely fearful that I was gonna lose my life. Just a few days later, Jorge Gomez here in Las Vegas also lost his life by the overt use of force due to the Metro Police Department. And so I just wanna ask you all to support this bill, not specifically to just address what's going on in Reno, because Las Vegas Metro Department has just previously spoke about the work that they're doing here, but to take it further and hold people accountable for the injustices and the abuse that people have faced throughout the whole 2020 year. And not only at the May protest, but throughout the whole summer and continuing on to this year. I really appreciate you all listening to me. And please remember, if you are not supporting this bill, then you are not supporting Black folk. And if you're not supporting Black folks, then think about the side that you really stand on. Thank you. Have a nice day.
Thank you, caller. Once again, if you've recently joined us this afternoon, we are currently on support testimony for Senate Bill 212. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits, 810. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, my name is Nisa Sun, NISSA TZUN. I am a resident of Clark County and also the co-founder of the Force Trajectory Project and a representative of Families United for Justice, a nationwide network of families impacted by police homicide, connecting hundreds of families organizing for systemic change. I am in support of this bill. While it's not perfect, this is a great start, and I encourage Senator Harris to continue working with our directly impacted community, like our local chapter that represents over 20 cases of police violence. I'm speaking on behalf of Alma Chavez, mother of Rafael Olivas, killed by LVMPD, where she witnessed her son's murder and was denied access to him afterwards and was also denied being interviewed as a witness. According to what she experienced, Metro did not verbally identify themselves when they shot her son to death. I'm also speaking on behalf of Lori Benson, mother of Nathan Benson, a mental illness sufferer who was shot by police in the stomach and to this day still is in pretrial detention 8 years later. The wound in his stomach still unhealed because CCDC refuses to pay for the surgeries he needs to heal. The legislators who find this bill unnecessary are quite simply blind to the rampant police violence that exists in our state. You're not listening. Currently, we have an art exhibit focused on the experiences of families who have been impacted by police violence at the West Las Vegas Library. I implore you to please go and check it out so that you can open your hearts to the experiences of those impacted by police violence unleashed by the Nevada police. While I think there should be a complete ban of the restraint chair, I support this bill because limiting its use will undoubtedly save lives and protect people. The restraint chair is supposedly for de-escalation to help calm people down, but in reality, it's being used punitively as torture. And I know this because we have interviewed multiple witnesses and victims of the restraint chair and those who have lost loved ones to the restraint chair or have themselves been tortured in the restraint chair, meaning they were choked out while in detention. The trauma inflicted upon our impacted community needs to stop. Their voices need to be heard, and frankly, the legislature needs to be more proactive in sourcing the voices of those impacted by police violence. Thank you.
Thank you, caller. And as a reminder to those who have just joined, we are currently on support testimony for Senate Bill 212. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits, 555. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Yes, good afternoon. My name is Tina Acree. It's Teena. Last name is Acree, Acree. And I stand in support. I recently retired from the Navy after 20 years of service. And what I witnessed happened to my uncle, Byron Williams, on September 5th of 2019 in Nevada was uncalled for. He was chased, subdued, and pinned to the ground. There's body cam footage that shows some of the events. He told the officers over 21 times that he could not breathe. And the officers there ignored his plea and cry for help. Instead, they combated his help and used vulgar and inhumane languages to him. As a family member witnessing what happened to him was uncalled for. And my call to action here is seeing how you all are going to fix that. It's not okay for anyone to be murdered. It doesn't matter their size. It doesn't matter their nationality. This is happening in America. This is happening in Nevada. This happened to my uncle. And it's not okay.
Thank you, caller. Caller with the last three digits, 846. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
My name is Eric Farah, E-R-I-C. Last name Farah, F-A-R-A-H. I am the brother of Nicholas Farah, who was killed by Las Vegas Metro less than 2 years ago. While he was not an immediate threat to himself or others, he was immediately placed into a restraint chair when arriving at Clark County Detention Center. In under 2 minutes, 4 officers had killed him by not allowing him to breathe, all while several other officers and medical personnel were watching and within 6 feet of him. This is not uncommon. I've talked to numerous other inmates who have lost consciousness while also in the chair and have also come very close to dying as well. Clark County Detention Center, uses this as a weapon on a daily basis. This is a huge reason why many other cities and states have completely banned the chair. They've also killed multiple people. Not only is this a huge liability for the city and the state, but no other family members should also have to go through this. No action or discipline was ever taken by Las Vegas Metro or Clark County for killing my brother. They all still work there and threaten inmates that they'll kill you in the restraint chair like they did my brother. Although this bill is not enough, it is a great start. I ask on behalf of my family and my brother and his 2 daughters who will never see their father again to support this bill. Thank you very much.
Thank you, caller. Caller with the last 3 digits, 037. Please slowly state and spell your name for the record. You will have 2 minutes and maybe.
Tanya Brown, TONJABROWN, advocates for the inmates and the innocent. We would like to echo the comments made by the previous callers. And first of all, I'd like to thank Senator Harris for bringing this bill. This bill is long overdue. I do have a concern with the amendment, and just a suggestion. Under Section 4, subsection 4C, I think it should read that the person must be asked if they have any physical or physical disability before they are placed in a restraint chair for more than 2 hours. And if the answer is yes, then it should go back to subsection 3, subsection D. And I believe that the restraints should be removed every 15 minutes, allowing the person to stand and then be placed back into the restraints of a chair, restraints in the chair. And I say this on personal reasons. If I'm saying hypothetically that if I got arrested and I was placed into a restraints chair, I would have I have a disability and I would have some issues with being in that chair. And if I was in there for any length of time, I could see becoming a little upset to where they could use extended force on me. I have nerve damage due to a back injury, and if I have to sit around in a chair or in a restraint, it would lead to some excruciating pain that I would not want to be subjected to, and I would be very vocal about it, and I could see myself or somebody else being vocal about it and then being restrained even more. So I think that should be looked at. Thank you very much, and have a good day.
Thank you, caller. Caller with the last 3 digits, 318. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon. This is Kendra Birchie with the Washoe County Public Defender's Office, KENDRABERTSDHY. I first want to thank Senator Harris for championing this incredibly important issue. I believe that everyone on this committee heard the cries from the community members demanding that there be change for some accountability and transparency with the police agencies in Nevada due to the deaths that have occurred here in Nevada. We really appreciate all the hard work that's been done on this bill with all the stakeholders. I'll again echo that it's not perfect. We're working towards ensuring that there is additional transparency and accountability. And in the interest of time, I do hope that you guys really listen to the impacted folks who are demanding change and demanding it and deserve it now. Thank you.
Thank you, caller. And as a brief reminder, we are currently on support testimony for Senate Bill 212. If you'd like to provide support testimony and have just joined us at this time, please press *9 now to take your place in the queue. Caller with the last three digits, 611. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. I'd like to thank Senator John Pirro, JOHN, PIRO from the Clark County. Thank Senator bringing this important measure forward. If you want something you've never had, you have to do something you've never done. And it's time for us to reckon with things we've never reckoned with. And I think it's also time, and I can say this as a white man to the other white men on this committee, that we need to acknowledge that sometimes our experiences aren't the same as our black and brown counterparts. It's going to be uncomfortable for me to hear and see and listen and look at things I've ignored for far too long and reckon with it. But it's time that we do reckon with it. As a person that was out legally observing at the protest, I did personally witness Metro shoot people in the back with pepper bullets walking away. I watched them gas people without appropriate warnings. I watched them do things that were inappropriate. And so there are things that we have to look at and talk about and have uncomfortable conversations with each other so that we get to a place of good policy that is good for all of Nevadans, that protects both our community and the police officers that are trying to protect our community. So it's okay to be uncomfortable, but we do have to get there and move forward. I thank you for your time.
Thank you, caller. The caller with the last three digits, 007. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. This is Lisa Rasmussen on behalf of NACJ, LISARASMUSSEN. I want to thank Senator Harris for bringing this bill forward. NACJ supports the bill. We don't love some of the amendments that were made, particularly with regards to the restraint chair issue, which is an issue that's been mentioned by others. But we absolutely will continue to work with Senator Harris on the bill, and knowing just not everybody gets everything they want in a bill, and I applaud her for the work that she's done on this. Mr. Pirro is exactly right. My experience as a white person is different than the experience of many of our clients who are colored, persons of color. They're black, they're brown. I think that this bill is really important, and NACJ supports it. Thank you for letting me speak. I don't want to repeat kind of what others have said.
Thank you, caller. Another reminder, we are currently on support testimony for Senate Bill 212. For those of you who have just joined us, if you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits, 887. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Chair Scheibel, Vice Chair Canizero, members of the Senate Judiciary Committee. My name is Corey Solferino, C-O-R-E-Y, S as in Sam, O-L, F as in Frank, E-R-I-N-O, and I represent the Washoe County Sheriff's Office. I want to take this opportunity to thank Senator Harris for her tenacity and passion for this bill. She's been in active dialogue with law enforcement, public defenders, district attorneys, and other community stakeholders during the interim and well into this 81st session. Senator Harris has been interested in learning industry best practices and standards in law enforcement, has been instrumental in bringing all parties together to foster mutual respect and understanding. The Washoe County Sheriff's Office appreciates her efforts, and with the amendment presented today, we are in support of SB 212. The Washoe County Sheriff's Office believes in increased training opportunities and policy guidance when clearly and thoughtfully crafted to help build a stronger law enforcement community. I'm proud to work for a progressive agency which has addressed these criminal justice reforms over the course of the last 10 years and continues to strive for industry best practices as stewards of our community. Many of the provisions of this bill are currently in practice at the WCSO. De-escalation techniques were instructed to me in 1999 in my regional law enforcement academy and called verbal judo. They've evolved over the years into enhanced active listening skills, critical incident and stress management, and the 40-hour block of crisis intervention training being taught in our academies and agencies today. These are not new concepts. Officers do not want to use force until they must protect life, the life of others, and to effect a lawful arrest. Law enforcement takes a reactive role in most use of force incidents where the subject has an opportunity to comply and chooses otherwise. Use of force incidents are compounded exponentially when you account for the mental health issues and substance abuse dependency plaguing our communities today. The creation and deployment of our MOST teams, CIT officers, ODMAP spike alerts, and evidence-based practices drive programs that direct law enforcement efforts to be more effective and efficient in their response. Currently, the WCSO completes over 23 hours of in-person annual training and an additional 26.5 hours of virtual, interactive, and online training minimally. They are to follow legislative mandates, post recommendations, and agency directives. Our recently completed community survey was overwhelmingly positive, but we've identified room for improvement, and Sheriff Balaam will champion those recommendations with his executive team to ensure we are listening to the community we serve. We are happy to represent Northern Nevada law enforcement and appreciate the overwhelming support we have of our community. We are proud to serve you. We are committed to community. Chair Scheibel, Vice Chair Canizero, members of the committee, thank you for the opportunity to speak before you today. We encourage your support of SB 212 as amended.
Thank you, caller. Caller with the last three digits 196. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel, members of the committee. I'm Eric Spratley, the Executive Director of the Nevada Sheriffs and Chiefs Association, here in support of Senate Bill 212 with the amendment, and appreciate Senator Harris working with all the stakeholders in such a thoughtful and considerate manner. It is because of this cooperative deliberation and the resulting amendment before you today that we are able to arrive here in a supportive position. I do need to be clear that the Nevada Sheriffs and Chiefs Association does not agree with many of the inflammatory points made in Senator Harris's presentation, most especially the bias and errant data presented to this committee from mappingpoliceviolence.org. Go to their website, look at their flawed methodology. They consider death at the hands of an off-duty officer in their data. So if an off-duty cop is a father and hears his child scream for help in the middle of the night in the next room and rushes in to find a person who's broken in and is raping his daughter, and the off-duty cop strikes him to stop the assault, but the assailant dies, that killing, quote unquote, would be entered into the mapping police violence database as an unarmed civilian killed by police. That's absurd. Their data is flawed based on their own methodology. On another matter, modern law enforcement worldwide has done away with this 1970s, quote, use of force continuum or a stair-stepping method of considering force that you've heard here today, as it increases potential for excessive use of force or an improper stepping down from force. So law enforcement finds that proper training in a use of force decision-making process, coupled with the de-escalation training in an effort to reduce use of force incidents, is the optimal way to train officers in the application of force, not a use of force continuum. For Section 3 of the bill, the Nevada Sheriffs and Chiefs Association did query the sheriffs and chiefs of police on use of force data collection and reporting to the FBI, and found that 63% of those that responded to that survey do not currently report to the National Use of Force Data Collection, but 53% support doing so, and 36% are neutral on the idea. So Section 3 is doable for our members. So again, we're here in support of SB 212 because Nevada law enforcement can comply with the provisions of the amended language, and because Senator Harris has worked very well with us to arrive at this amended language. We don't support the presentation or appreciate the guest presenters and their hatred for police, but we do support Senator Harris on the bill.
Thank you, caller. Caller with the last three digits 771. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Leslie Turner, Leslieturner. First, thank you, Senator Harris, for bringing this bill forward. It's a step forward in addressing the police violence that we've seen in our communities my entire life. Simply because taking a life can fit into the framework of policy doesn't make it justifiable in the broader society. We have to move towards making sure that we are putting human life at the forefront always. And when a person dies at the hands of law enforcement, we should look in depth at what happened there and objectively try to prevent it from happening in the future. I have watched many body cam footages. I have watched recorded cell phone footage of numerous people being killed by law enforcement. And when we watch these videos, it should not be through the lens of figuring out whether or not the loss of life was justifiable within policy. Rather, we should be looking at what could have been done differently to preserve life. A life lost is a failure. Someone on the panel said that the police keep us safe. I think that that's a very subjective statement. And it also erases the experiences of Black people, undocumented people, people in my community who, when we see the police, we actually don't feel safe. We actually feel the opposite. So again, maybe it's for you in your neighborhoods, but policy also needs to represent our will. Individual officers that want to do the right thing, that's also not the issue. Nor are we debating back and forth on how many Black people have been killed. It's actually sickening that we throw out an arbitrary 4 of them were Black, because like their lives also mattered. And what this is actually about is systemic racism ingrained in the fabric of this country that's also ingrained in the system of policing. There's lots of data, lots of things written on these topics that we can educate ourselves on. When it comes to data, we have to stop using absolute worst case scenarios possible rather than listening to what's actually happening to people on the ground in over-policed communities right now in our neighborhoods today. And also, calling out injustice is not hatred. The community that lives these policies every single day, that are policed in our communities every single day, our voices are also valid, and we are experts on the things that have happened to our families and happened to our loved ones. The community needs to define what keeps us safe, not law enforcement. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give support testimony at this time.
All right, thank you so much, Mr. Kyle. I just want to confirm for everybody listening in that there's nobody else in the queue to give support testimony.
That is correct, yes.
All right, in that case, we will move on to testimony in opposition. I also want to let the committee and those listening along know that I have had a chance to reach out to my co-presenter on SB 258. That is my bill. I will be moving this bill to another day, most likely Monday at 1 p.m. to allow plenty of time for all of the testimony in opposition and neutral before we have to get to other committees and other meetings. I apologize for the inconvenience for anybody who is here to hear SB 258. Please feel free to call my office personally and complain about it. But in the meantime, we are going to move on to opposition testimony on SB 212, and each caller will be given 2 minutes to speak. Thank you.
Thank you, Chair Scheibel. To testify in opposition on Senate Bill 212, please press *9 now to take your place in the queue. Once again, to give opposition testimony on Senate Bill 212, please press *9 now to take your place in the queue. Caller with the last 3 digits, 982. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak, and maybe.
John Abel, Johnabel. I'm with the Las Vegas Police Protective Association, representing 3,500 law enforcement officers in Southern Nevada, as well as PSAN, who represents law enforcement officers in Southern Nevada and Northern Nevada. We represent the officers who use this use of force model. The decision to use force is never an easy decision for an officer. However, as a part of our profession is already heavily regulated, and attempting to regulate it further with subjective language will cause confusion and cause peace officers to get possibly injured or killed. The concerns of the LVPPA and its 3,500 represented law enforcement professionals are as follows. In Section 2, this section goes on to talk about training as it relates to use of force and use of force under subsection 3. The LVPPA would welcome the following. Each law enforcement agency shall adopt a written policy and provide training to a police officer regarding the potential threat of serious bodily harm or death to the peace officers or others, quote unquote. The LVPPA would object to subsections 1 through 7 and would ask for the removal of these areas based on the following. Making statements of how the training should identify a subcategory of who lawmakers, quote unquote, feel aren't or do not pose a threat to an officer are not needed to be addressed in law, and and or policy. To mandate a policy in the section on best practices is fair enough. Every time an officer uses force, whether it be low level or deadly force, many factors go through an officer's head. Those factors include officer making an assessment on the threat itself to include the subject's ability. LVMPD policy relates to 4 factors. It's the ability, someone's ability to do harm to another, opportunity, typically closely linked to proximity. Am I close enough to harm you? Can I harm you? Imminent jeopardy for deadly force and jeopardy for non-deadly force. A reasonable fear that something is going to happen or is about to happen, and preclusion. That all the reasonable options have failed and would have failed. These four cornerstones for force cover a wide range of avenues for using force. There is no need to outline what the training should encompass. That should be decided by the agency as long as they connect the above 4 cornerstones of force. Under Section 3, it states the number of police complaints as well as sustained complaints for force will be collected. The LVPPA would oppose any position action. Okay. In regards to peacefully assemble, most people did peacefully assemble last summer, but there were some mix in the crowd that were intent to cause harm, throwing projectiles and injuring officers. Officers must retain the ability to use non-deadly tools to disperse crowds.
Thank you, Chair. Once again, if you've just joined us this afternoon, we are currently on opposition testimony for Senate Bill 212. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place. Caller with the last 3 digits, 877, please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Good afternoon, Honorable Chair Scheibel and honorable members of the Senate Judiciary Committee. My name is Ron Dreher. I appear before you this afternoon by phone to ask that you oppose SB 212. I am here as an honorably retired Reno Police Major Crimes Detective on behalf of the Reno Police Protective Association, as a member of the Public Safety Alliance of Nevada, and on behalf of our families and victims of crimes in our state. First and foremost, police do not use force based on race. Police use force based on the actions of the person they are dealing with. Police officers follow the use of force policies when dealing with the public. Officers are very well trained and employ the use of force continuums to guide them. No officer goes to work hoping to hurt someone. All officers go to work hoping to save someone. When an officer is required by the situation to use force, they do so only to the level necessary to control the situation. Codifying the use of force provisions as described in this bill is and has already been part of all of the policies and procedures of our law enforcement departments in Nevada. We have had and do currently utilize an escalation of force policy. Contrary to what has been said in this committee, we are not racist. The police use force when it's required. What requires and dictates the use of force, the actions of the person and the officer is dealing with. What is not in our policies and procedures, those provisions of Section 2, Sub 3, because these provisions place huge obstacles on police officers when encountering suspects in crimes. How do you codify subjectivity? How do you codify a person's age? If they are physically frail, their mental condition, or if someone is pregnant, etc. Another section is Section 2, Sub 1. The ambiguity of this section requires the officers must use de-escalation techniques wherever possible. They already do this. Incidents turn deadly in an instant. Our training teaches us to react immediately to a deadly situation. A deadly situation can occur in an instant like that. To state in Section 2B to use force that is objectively reasonable, how do we codify that? The bill handcuffs our peace officers and allowing them to serve and protect. This bill will result in an officer or a member of the public being hurt or killed. Our police officers do need to have the authority to do their job. Look at Colorado, look at Reno, look at Las Vegas, look at Washington, D.C. We do not need to die at the hands of our peace officers by restricting their ability to do their job. Thank you, ma'am. 2 minutes doesn't allow us to enough time to talk the negative aspects of SB 212 and
Thank you, caller. And if you've recently joined us this afternoon, we are currently on opposition testimony for Senate Bill 212. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 294. Please press star 6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Chair Scheibel and members of the committee, this is Callie Wilsey on behalf of the City of Reno. That's spelled C-A-L-L-I-W-I-L, S as in Sam, E-Y. While we are here in opposition today, we have not had an opportunity to review the amendment in advance of today's hearing, and we look forward to doing so. We've reached out to the sponsor, and we're hoping to take part in the conversations on this bill going forward, along with the other law enforcement agencies that you heard from today. I did want to clarify for the record some information regarding the Reno Police Department's use of force policy and the data that was provided today. Our use of force policy has a use of force continuum. It addresses de-escalation. It includes comprehensive reporting. Additionally, it prohibits techniques that restrict a person's airway or ability to breathe. It requires a warning before using deadly force. Officers are required to intervene in excessive force situations, prohibits shooting at vehicles, as well as additional details that were discussed today. We also take exception to the data presented. Since 2016, we have had one officer-involved shooting involving the Reno Police Department in which a Black male has been killed. The data presented today is a misleading representation of what is actually happening in our community. With that being said, we understand how important this conversation is and value having that not only with the state legislator and with our community. RPD has shown a strong commitment to proactively and openly working with our community to address community concerns and updating their policies accordingly, and we remain committed to that. The bill sponsor mentioned anticipation of additional conversations on this bill. We hope that we will be invited to participate in those conversations. We will also be submitting a letter with additional detail about the Reno Police Department's use of force policy to the committee. Thank you.
Thank you, caller. Caller with the last 3 digits, 668. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may.
Good afternoon, committee chair and members of the committee. My name is Troyce, T-R-O-Y-C-E, Krumme, K-R-U-M-M-E, and I'm the vice chairman of the Las Vegas Police Managers and Supervisors Association and a member of the Public Safety Alliance of Nevada, representing numerous police associations having membership of over 10,000 peace officers across our state. I'm also willing to make myself available to any member of the committee on this important issue and would be encouraged to be included as a stakeholder. Today, pursuant to committee rules, I am testifying in opposition to SB 212. The purpose of a lawful use of force is to use a reasonable level of force to overcome resistance to bring a person into custody. I would encourage this language to appear in the bill should it move forward. In Section 4, subsection 3, letter C, I suggest language to the effect of, quote, when feasible, end quote. Sometimes the immediate need to use the restraint chair for the safety of the inmate and others can preclude the opportunity for prior notice to medical staff. In letter D below that, requiring a member of medical staff to perform an evaluation prior to the use of a restraint chair could unnecessarily place that medical staff member in physical danger. Mandating the evaluation as soon as possible after the person is in the chair should suffice and is the safest way to do so for everyone. I offer these particular words are not hyperbole, as just 2 days ago in an Iowa detention facility, a correctional officer and nurse were murdered by an inmate while in the prison infirmary. Safety to all persons, officers, jailed persons, and civilian staff should all be prioritized when discussing legislation such as this. Thank you for your time.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give opposition testimony at this time.
Thank you so much. And as always, I just want to confirm one more time for clarity of the record, Mr. Kyle, that there is nobody else in the queue to give opposition testimony.
Yes, Chair Scheibel, that is correct.
All right. In that case, we will move to testimony in the neutral position on SB 212.
Thank you, Chair. To testify in neutral standing on Senate Bill 212, please press star 9 now to take your place in the queue. Once again, to give neutral testimony on Senate Bill 212, please press star 9 now to take your place in the queue. And Chair Scheibel, while we have callers on the line, there are no callers to give neutral testimony at this time.
All right, thank you so much. Sorry, I'm just checking to see that we still have all of our members of the committee present. We did receive another BDR during the course of this meeting. It is BDR 14-375. And I want to make sure that all of the members of the committee have had time to review it. So is there anybody who needs more time to review the BDR, or are you ready for a discussion and possibly a motion on it?
Madam Chair, I'd like to have a little more time. He just literally came here within just a few minutes, and I've been trying to pay attention to the testimony.
I understand, and for that reason, let's go ahead and move to, let's just take a 2-minute recess, all right? And we'll come right back so that everybody can read the BDR, and we will reconvene in 2 minutes. All right, I will reconvene the Senate Committee on the Judiciary. Before I forget, I will now close, I will now close the hearing on SB 212. I'm sorry, Senator Harris, we did not have time to go back for any final comments or responses before we took our little break. Would you like to make any now?
I would not, Chair Scheibel. I think the committee has given plenty of time to this issue, and I appreciate everyone's attention. Thank you.
Thank you. All right. Having closed the hearing on SB 212, we will now open the conversation on BDR 14-375. Pursuant to Senate Joint Standing Rule 14, committee members must vote to approve the drafting of legislative measures requested by the Senate Committee on Judiciary on behalf of various entities. Please remember, a vote in favor does not indicate your support for the bill, but merely allows the bills to be drafted. Today, I request the committee's approval of BDR 14-375 requested by the Interim Committee on the Study of Pretrial Release. Is there a motion?
Move introduction.
There's a motion to introduce from Senator Orenshaw and a second from Senator Harris. Is there any discussion on the motion? Not seeing any, we will go to a vote. Would the Secretary please take a roll call vote?
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemeyer,
Yes.
Senator Hansen,
Yes.
Senator Pickard,
Yes.
Chair Scheibel.
Yes. And with that, the motion passes to introduce BDR 14-375. I appreciate everybody's cooperation with the second round of BDR introductions during this deadline period. And with that, I believe we are ready to move on to the last item on our agenda, which is public comment. Could BPS please allow anybody wishing to give public comment 2 minutes per person, starting now.
Thank you, Chair Scheibel. If you'd like to provide public comment this afternoon, please press star 9 now to take your place in the queue. Once again, to give public comment this afternoon, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 202. Please press star 6 to unmute. Then slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Thank you, Chair Scheibel and members of the committee. For the record, I'm Jason Guinasso, Guinasso. I'm an attorney for the Police Officer Research Association of Nevada. I tried to speak in opposition, but there was a technical difficulty, maybe on my part, so I'd like to give my testimony in opposition now as a part of public comment. As you know, PORAN represents 14 Nevada law enforcement associations and more than 1,400 law enforcement personnel across the state. PORAN opposes this legislation. PORAN opposes this legislation as currently written. However, PORAN does not oppose evidence-based police reform. PORAN supports evidence-based efforts to improve how police protect and serve our communities. Unfortunately, some of the proposals in this legislation to change how police use force are not supported by peer-reviewed evidence, data, and the decades of experience of police officer professionals regarding best practices in policing. Rather, this proposed legislation is largely supported by narratives of extreme and tragic incidents of a few bad actors or narratives that have been aggregated in a database. While narratives and narrative evidence are useful to help understand why the legislation might be needed, narratives do not supply evidence as to why the proposed changes to the law and policy will improve upon the work being done by police to protect and serve our communities. To our knowledge, there has been no effort by the bill sponsor or any of the supporters of legislation to provide evidence supporting the assertion that the changes to the law will actually improve how police protect and serve our Nevada communities. The senator referred to best practices, but best practices do not provide evidence to show that those proposals were in fact best practices. By contrast, the current law and policy at the state and local level regarding police use of force has been developed over the past 50 years based on evidence, data, and experiences of law enforcement. While there is always room to improve, we respectfully submit to you and the committee that the proposed changes to the law contained herein have not been subjected to the same evidence-based review and scrutiny supporting our current law and policy at the local level. PORAN is willing to work with Senator Harris and others on evidence-based reforms to police use of force. Unfortunately, to date, the senator has not invited the officers from our association to have a seat at the table when drafting this legislation. Madam Chair, I am sure working together we can achieve the good intentions of Senator Harris and others who want to codify policing best practices and improve how police officers protect and serve our communities. Thank you very much.
Thank you so much for your testimony, and I would ask that the record reflect that Mr. Guinasso's testimony was in opposition to SB 212. Even though we have closed the hearing on that bill, we will add your testimony to the record as if you had called in during opposition and not had the technical difficulties. And with that, we will return to public comment.
Thank you, Chair Scheibel. Once again, if you'd like to provide public comment this afternoon, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 767. Please press star 6 to unmute. Then slowly state and spell your name for the record. You will have 2 minutes to speak.
Hello, my name is Tanisha Freedom. freedom for free 'em all, let the people sort them out. I would like to also add testimony in regards to SB 212 neutrally. I was also experiencing a technical difficulty and could not get my phone to unmute at the time. I'd like to state that, you know, the use of force policy has to be discussed, reviewed, and revised, including accountability, definition, and consequence, because people have been harmed and have been killed in these situations with the police. As one call stated earlier, a death for any reason is a failure. I have witnessed myself and been harmed by excessive force while in public, while held kidnapped in various jails or concentration camps, and also during protests. Language in some areas needs to be improved, especially in the sections that state may instead of must, as we know that is always ambiguous. I've also witnessed in person a kidnapped protester physically assaulted and then restrained inhumanely in a restraint chair after refusing to put his hands in his mouth to allow officers to see if anything was in his mouth during a time of COVID. He requested gloves, he requested his hands to be washed, he requested hand sanitizer and was denied that. And when he refused to stick his hands in his mouth, he was physically harmed, restrained in a chokehold, and then put into a restraint chair. So these are things that we've seen in person, in custody, and on the street. Also kettling, pepper gas, and not being allowed to safely disperse during protests has also happened, you know, during times of protests in Las Vegas. So we need to be more diligent with oversight on the use of force policies in this state and in our cities. And what we see across our state is that it's inconsistent. We see Las Vegas, Reno, North Las Vegas, Henderson, varying in the levels of, you know, the consistency of their policies. So I believe that this bill may attempt to provide some consistency over these policies. Thank you for your time.
Thank you, Ms. Freedom. And again, I would like the record to reflect that her testimony was in the neutral position on SB 212. I understand we all have technical difficulties, so I want to make sure that is properly recorded in our minutes. And now, once again, let's return to public comment.
Thank you, Chair Scheibel. As a final reminder, we are currently on public comment. If you'd like to provide public comment at this time, please press *9 now to take your place in the queue. Caller with the last 3 digits, 556. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT. My brother Thomas Purdy was hogtied for 40+ minutes by Reno police during a mental health crisis and then asphyxiated to death at the Washoe County Jail while still hogtied. The officers who put my brother in the Rip Hobble torture device at the Peppermill Casino kept him face down with the knee in his back and neck while hogtied. Well, they filled out their paperwork, never turning him over onto his side into a recovery position the whole time. I can provide the police reports. My brother never assaulted anyone. He was terrified out of his mind someone was trying to kill him and asked for help. No ambulance was ever called even after being put in the torture device for over 40 minutes. I can't speak to Clark County, but I can to Washoe County. If someone were to die in Washoe County by means of asphyxiation, DA Chris Hicks does not investigate like he does in officer-involved shootings. The officers who put my brother in the torture device at the Peppermill, I'm sorry, I already read that part. Honestly, until Graham v. Connor and Tennessee v. Garner are overturned, the whole reasonableness thing, and DAs prosecute police who use excessive force or kill due to negligence, I feel like watered-down bills are just putting a Band-Aid over a deep wound. Watered-down bills are not designed to prosecute police, but rather to restore public confidence in the police. They are used to diffuse demands for prosecuting police brutality and minimize punishment for guilty cops. What families really want is true change so no other family knows this pain, and for our loved ones their killers to be held accountable as anyone not wearing a badge would be. People who want accountability and transparency are automatically labeled cop haters. That's pretty telling. I don't hate cops. I dislike bad cops and those who cover up their wrongdoings. And just some data, 6 people have been killed during interactions with police in Reno, Washoe County, Nevada since the year 2000 who identified as Black. Lyon County, interesting fact, the last man killed was 66-year-old Owen Earl Barton on January 16, 2020. His 13-year-old grandson, who was autistic, was later shot by Salt Lake City PD on 9/5/2020. Thank you.
Thank you, Chair Scheibel. And with that, there are no more callers to give public comment at this time.
All right, thank you so much for your help. Having completed all of the public comment, that concludes our hearing for today. We will be meeting tomorrow at 1 p.m. and we are now adjourned.